security, a provision of adequate security during infringement proceedings. All the decisions that we are going to take a closer look at today are decisions which come from the dispute between InterDigital as the claimant here and Oppo as a defendant. So we have two decisions. The first one was delivered in February this year, and the second one in the end of May this year. So we will start with the first one, which covers the topic of adequate security and security deposits. But before doing that, let's take some look at the story behind the case, some very basic facts in order to be able to understand where we stand at the moment with these proceedings and what has happened so far. So looking at the story between the two parties, it's something which goes back almost 10 years. So the first contact was already back in 2014 when InterDigital and Oppo started starting negotiations for a license. And since then, there has been no agreement signed. Almost 6-7 years later, in 2021, InterDigital then launched litigation, and it launched litigation in several jurisdictions, including India. Here, just for your information, there are two different proceedings pending. There is one proceeding in which InterDigital has asserted 5 wireless SEPs, and there is a second trial in which InterDigital has asserted HEVC patents, 3 HEVC patents. But apart from the proceedings in India before the High Court of Delhi, there have been also proceedings in Germany and the UK. We have in the past also looked at some of these decisions in our webinars here. In India, what happened in the proceedings at a relatively early stage was the establishment of a so-called confidentiality club. So this is a framework under which specific documents which are sensitive, here in our case mostly third-party agreements, need to be treated with some caution, and there are some limitations, especially on regarding which persons will be having access to this document. So this is what the court established relatively early in the proceedings, already back in August 2022. This was one part of the discussions in the proceedings before the High Court of Delhi. The other big question was how to provide adequate security to InterDigital during the pendency of the proceedings. And this was especially a very important issue here because InterDigital had asked, among the other claims that it had asserted, for the court to establish a so-called pro-term arrangement, which is basically a provisional arrangement, a provisional payment until the end of the proceedings. So this was the claim which InterDigital had asserted in these proceedings. And there was a question in the proceedings discussed how to meet that, under which conditions. There were, Oppo had provided in the past 2 bank guarantees issued by Chinese banks, which InterDigital did not agree to be used also here in the proceedings in India for security. So what happened then in September 2022 is that Oppo provided 2 further bank guarantees, which this time were issued by a French bank, HSBC Paris. And then there was a lot of discussion in the proceedings whether this is now sufficient security also for the proceedings in India, because mainly these were bank guarantees issued abroad, and they were also issued in relation with the parallel pending proceedings in Germany. At some point, the parties agreed on specific conditions, which we're going to take a look at in a moment, of using these bank guarantees from France also in the proceedings in India. And that's when the Delhi High Court issued a consent order laying down these conditions for the use of these bank guarantees in the proceedings before the High Court of Delhi. So this was in October 2022. The court agreed to use that as a security, but again, it placed some conditions. And what was interesting here was that these conditions were not met by Oppo, respectively by the bank. So in March 2023, Oppo filed a request asking for a modification of this consent order. This is when InterDigital then refused basically to consent again with Oppo, to agree with Oppo on providing new bank guarantees. So there was a suggestion that Oppo would issue new bank guarantees, this time by an Indian bank, and then offer that to the court. So the question here was then, is this enough? Can they provide that adequate security now with bank guarantees again? Or, as the InterDigital asked, should now Oppo be ordered to make a deposit of the specific amount? And this is a change insofar, or there is a difference, because with the bank guarantees, the implementer, to put it very simple, they pay an amount to the bank, but they don't have to pay the whole amount of the security, because if something goes wrong, then it's the bank that needs to pay this amount. On the contrary, when you have a deposit, then the whole amount of the security must be paid by the implementer. So there is a difference here, and at that stage of the proceedings, InterDigital insisted into that Oppo would provide a deposit now and no longer a bank guarantee. So this was the stage of discussions in the proceedings before the High Court of Delhi. What happened in the meantime was that the Munich District Court decided the case on the merits and decided in favor of InterDigital, granting, among others, also an injunction against Oppo. So this is something that we're going to see in a while. It was something that the court considered here. And then after that happened, the court delivered its decision in February 2024 about what form of security needs to be provided now by Oppo. And this time the court ordered Oppo to make a security payment, to make a security deposit. We're going to see in a moment under which specific conditions. So this was the first part. Then the court also, with this decision, made a slight modification on the confidentiality club that had been established in the past. So we're going to see also what was the change that the court supported here regarding the confidentiality protection of specific documents in these proceedings. And then with the second decision, the court also decided on specific requests which both parties had filed here, to produce specific documents. And interestingly, the requests affected two agreements which the parties had signed with Qualcomm. So it was one agreement between InterDigital and Qualcomm that Oppo requested to be disclosed, and there was also an agreement between Oppo and Qualcomm that InterDigital requested to be disclosed here. And apart from that, there were two agreements with other parties, between Oppo and Ericsson, for example, and Oppo and Orange, which InterDigital requested the court to order Oppo to disclose. So with the second judgment on the 31st of May, the court delivered its ruling here and ordered disclosure of specific documents, not all of them. So we're going to take a look at that more in detail in a second. Just here to keep in mind, the proceedings in India are still ongoing, so we don't have a decision on the merits. As far as we can understand from the decision itself, there is an ambition by the court and the parties to have a decision until the end of 2024 or the beginning of 2025. So we will have, of course, to wait and see if this will come, if this will be the case. And of course, we will cover this decision as well, if and when it comes. So here, looking at the first case and focusing at the issue of security, of what is adequate security, the first question that the court had to ask itself here and to answer was whether these two foreign bank guarantees from HSBC Paris would be acceptable for the proceedings in India. And as we have already said, the parties agreed that under specific condition they should be seen as sufficient. And here, just for us to have to keep that in mind, these are the conditions which were laid down by the court in this consent order that was delivered in October last year. So here, the first condition was that the originals of the bank guarantees should be delivered to InterDigital and kept by InterDigital. This is something which was specific to the bank guarantees we were talking about here, because basically there was a provision there not allowing to withdraw or to cancel the bank guarantees unless the person has actually the originals. So the court and the parties agreed that to increase security and to make InterDigital's life easier, the originals should be given to InterDigital, and this was actually what happened here. They were delivered to the German External Council of InterDigital and kept by them. So this was the first condition. Then what the court actually asked here was that the two bank guarantees should remain valid and renewed throughout the pendency of the trials in India and not be cancelled by Oppo without permission of the Delhi court. So the Delhi court wanted that these guarantees would be in place throughout the proceedings and not risk anything happening in the meantime, which would basically cancel the guarantee and also cancel the security provided to InterDigital. Then what the court also said, the third condition was that these bank guarantees should constitute security for any orders of the Delhi High Court as well, including any potential payments to InterDigital. Meaning that if the court in India would order at some point in time Oppo to make specific payments to InterDigital, then InterDigital should be able to use these bank guarantees. And this was a condition, again, indicating that there should be a strong link of these bank guarantees, although they have been produced and issued abroad to the proceedings in India. So the Delhi court should have a control about what is going to happen with these bank guarantees. And this is even more clear with the next condition. The court said that the bank guarantees shall be subject to the jurisdiction of the Delhi High Court. This means also in the same time that Oppo shall refrain from proceedings in any other jurisdiction, which would eventually, for example, seek cancellation of the bank guarantees or withdrawal, etc., as long as the proceedings in India are alive, and they should not be able to do that without permission of the Delhi High Court. So again, here, this indication that the Delhi High Court should be in control of what happens with these bank guarantees. Apart from that, there were some clarifications regarding the nature of the bank guarantees and the amounts that were covered by them. For example, it was made clear that the amount of the bank guarantees shall not be deemed to be the final front determination in the present case. So, meaning that the amount of the bank guarantees is not necessarily actually the front price which Oppo needs to pay to InterDigital. This could be more, this could be less, but definitely it's not this amount. And also another caveat that these bank guarantees do not create a liability of Oppo to pay any amount to InterDigital. So here the clarification also that this is a provisional arrangement and it does not create a liability to pay this amount, which is covered by the bank guarantees. Then the question, what would happen if this bank guarantee is discharged by orders of foreign courts? And this was a realistic scenario here because, as we said, these bank guarantees were also used in the context of the German litigation. So what would happen if there was an order by a German court, for example, here, which would take away an amount from these bank guarantees? What should happen then? Then the Delhi High Court would have the possibility to order adjustments of the bank guarantees, of the amounts, in order to be able again to establish an adequate security for the proceedings in India. And what was, let's say, the price that InterDigital paid for having this security play in place? The deal was that InterDigital shall not request any interim injunction or any other security as long as these bank guarantees are there under the conditions described before. What the court and the parties also mentioned in this consent order was again what we said before, that the trial in India should now be expedited, so it should be moving faster, because here, just for a reminder, we have already almost 3 years in these proceedings without the final decision. So again, the ambition is to conclude the proceedings by the end of 2024 or early 2025. So these were the terms which were, let's say, not problematic. There was one term, one condition, however, which was problematic, and which was the one that also led the court not to rely anymore to these two bank guarantees which were issued by HSBC Paris. And this was this last condition. The court asked representatives of both Oppo and HSBC India to appear before the court and confirm acceptance of these bank guarantees. So this was the final condition which the court set up here in order to accept these French bank guarantees for the proceedings in India. And although Oppo's representatives appeared and made this confirmation, HSBC India did not. On the contrary, they refused to make this confirmation and basically argued that they cannot make this type of confirmation on behalf of HSBC Paris because they have no direct connection with this other bank, and the best thing that they could do would be to send an email to HSBC Paris and basically share the answer of HSBC Paris with the court. But they refused to make this confirmation that the court asked here. And this is basically where then this whole construct here did not work anymore, because this condition was not met. So the court needed to decide what to do now, what to do next. And again, here we had this proposal by Oppo to issue new bank guarantees by banks in India this time. And this was something InterDigital did not want anymore. So the court needed to decide here how to proceed further. And the first question it asked is, can we do that? Can we have a further bank guarantee? Would it be enough to safeguard InterDigital's interests here? And the court found that this would not be the case. And it looked at the balance of the interest between the parties, but also very much into the behavior of the parties, the conduct of the parties. And here the court criticized the stance of both the bank and also Oppo. Looking at how HSBC Paris and HSBC India acted here by especially refusing to make these confirmations, the court found that this was completely unacceptable. And it also found that Oppo is more or less liable for this failure to make this confirmation. It was very clear here, the court said that Oppo miserably failed to meet this duty to ensure that HSBC would provide with this confirmation. So it clearly found that it was Oppo's fault that this order, this consent order, did not work in the present case. And now that these conditions were not confirmed, the court added that if you have a bank guarantee which is subject to jurisdiction of a foreign court, as we have here, absent all of these guarantees that we have seen already, which the court wanted to have here in order to make sure that the Delhi court would have some type of control of what would happen with the bank guarantees in the present case. Then, if you have this type of guarantees with not without of the safeguards which the court formulated in the past, then a guarantee coming from abroad will not be sufficient security for proceedings in India. So that's what the court also said here. What would happen if we have guarantees issued by an Indian bank? Would this make any difference here, especially in the specific case? The court said that it had considerable doubts that now at the present stage you could have a sufficient security by bank guarantees, even if they were issued by banks in India. And here it looked more at the broader picture. So it basically said, irrespective of the fact that we have the proceedings pending since almost 4 years, Oppo nevertheless continues having sales in India and generates profits in India, being, at least in the eyes of the court, very successful as well. The court found that they have a market share of almost 60% in the Indian market. And on the other hand, the court noted that there is some strong indication that Oppo faces severe financial difficulties in India. So there is a need now to have something robust set up as a security in favor of InterDigital. And looking apart from that, on the whole, at the whole history of the parties, the court noted here that they are in negotiations with InterDigital for almost 10 years without a result, which in the eyes of the court is very strange, because it saw no reason why the parties have not entered into an agreement yet. Respectively, also mentioning here the decision of the Munich District Court, which had granted an injunction against Oppo in the meantime. So here, again, the court saw that there is a need to have a robust security in place, because all of these, the very long time that parties have been negotiating without success, the fact that there are some financial difficulties for Oppo in India, all of this spoke in favor of giving a robust protection to InterDigital here. And this would be now in the form of a deposit, a security deposit. And looking at that, the court said this is also something not particularly new in India. There has been a practice emerging in India that courts have confirmed the necessity of this type of provisional deposits, security deposits. And it mentioned several cases which this has been done in the past, in the recent past, among them the Intex versus Ericsson decision. But, and this is also very interesting, the Nokia versus Oppo decision, where Oppo was again asked to make a preliminary deposit, security deposit. We're going to take a look at that more closely in a moment. So this was the court deciding that a security deposit should be placed here. And then the question was under which terms? So how should the security deposit look like? And the court said that in principle, what we should do here is to avoid that by placing the security deposit, Oppo would be better positioned than what they were with the consent order and the bank guarantees that we had already. So here, then the court turned to determine the sum, what would be the amount that should be paid here. And it required Oppo to pay a deposit of a sum representing the amount of the latest bank guarantee which Oppo had submitted in the German proceedings, which seems to be aligned with the amount which would mirror the share of Oppo's sales in India compared to the global sales. So they would basically use the share of Oppo's sales in India compared to the global sales, which would amount between 23 to 25%. Then, apart from that, the security deposit should not cover only the latest sales, but it should cover also past sales for the years 2021, 2022, 2023, 2022, 23, and also 2023, 2024 until the end of 2024. This should be the amount. And then the court also asked itself what would happen after the end of 2024. So we said here, of course, that the ambition of the court was to end the proceedings until the end of 2024. But what would happen if this would not happen? Then the court said you would also need to place an additional amount for security, and you should deposit that until the end of March 2025 if the main trial is not concluded by December 2024. So there is also, let's say, the option to pay an additional amount of security if the proceedings would move on over the end of 2024. Now, what would be the consequence if Oppo failed to make this deposit? Here, the court was very clear that there is a severe consequence attached to the failure to make the deposit as ordered, because then InterDigital would be entitled to seek an injunction banning further Oppo sales in India. So basically, if there is no deposit paid within the conditions that the court has determined here, Oppo should stop its sales in India. One final remark here, because I think it's also an interesting point. Apart from laying down this very strict consequence for non-compliance with this order to make the security deposit, the court also imposed a fine of approximately 5,000 euro to Oppo, basically for the delay that it has caused through the non-compliance with the consent order and the problems that had occurred with the bank guarantees. So this was not related to the payment, to the deposit payment itself, but it was another indication here that the Delhi court was very unsatisfied by the way Oppo had acted and found it appropriate here to impose also this fine on them due to the fact that they had not been able to comply with the consent order that the court had delivered before. Here, the court, of course, asked itself the question whether you should have any protection of confidentiality at all in this type of proceedings. And it found basically that this should be the case. Of course, as a principle, in litigation, you must have all documents and pleadings of the parties exchanged between the parties, so that each party can know what the other party is pleading and respond to that. But the court recognized here that due to the increasing complexities in trade and commerce, there are now mechanisms required to share confidential information. And this is exactly the function of this confidentiality club that was established by the court here, giving a framework for allowing the parties to share information which is confidential in a way that they will not be harmed. And in this context, of course, we will see also the interest of the other parties which are not involved in the proceedings. The third parties are always an issue that needs to be considered. So what the court then did here was to have some reflections of whether there are any specific elements in SEP litigation that need to be taken into account when it comes to protection of confidentiality or establishing this type of confidentiality clubs. And here the court looked at what type of information or what type of documents are usually relevant in these proceedings. And it saw that it's about global agreements, usually that shall be disclosed and used in litigation. And said that basically for this type of agreements, for this type of documents, usually you should have a limitation of access, but access should be granted usually only to external counsel of the parties or external experts of the parties. For example, as we have seen here, there was access or granted, there was a confidentiality club set up, and this would include the counsel of the parties in the proceedings, for example, or external experts that they might use in the proceedings. The court was a little bit more hesitant to allow access to the documents to employees of the parties. And it said basically that if you have any persons or employees that can take advantage of the information included in these agreements, or which is going to be subject to the confidentiality club, and can use this information later on in negotiations with third parties, then you should obviously be very careful of including them into this confidentiality framework. The reason for that is very obvious, because they would get a competitive edge towards the third parties if they are included into the confidentiality club and get access to this information. This will be known to them anyway, so they can use that in any case in third party negotiations. And the court found that if this happens, then the entire purpose of a confidentiality club would be completely defeated. So it doesn't make sense basically to include this type of persons that are in direct negotiations with third parties into a confidentiality regime. Now there are, however, some exceptions which the court also recognized here. You could use or include internal officials in this confidentiality framework, but if you do that, you have to ensure that these persons will not compromise the integrity of the information in any matter or utilize the same information for third-party negotiations. So if you include internal officials in the confidentiality club and allow access to confidential information also to them, then you have to lay down specific conditions, reasonable conditions, as the court put it here. And in these conditions should also reflect the interests of third parties that are not involved in litigation. So the court had also that in mind here. And here particularly, the question was whether to include internal representatives into the confidentiality club. Because in the initial decision of the court, if you remember, we said the court had established a confidentiality club relatively early in the proceedings with only external experts. So there were experts, one from InterDigital and one from Oppo. The external counsel of the parties were included in this confidentiality club, which were three from each party. And also the foreign external counsel, these were the lawyers of the parties in the German proceedings, for example, were included in this confidentiality club, but no internal representative initially. And then Oppo requested that internal representatives will be added. And looking at the specific situation here, the court decided to allow this. So it allowed also two internal representatives of each party to be included into the confidentiality club and get access to the documents, including comparable agreements. But here the question is under which conditions, and the court laid down these conditions in this ruling as well. It basically oriented itself to the law. There are two main sources which the court relied upon from the Delhi High Court rules, Chapter 7, Rule 17, and Annex F, which refers to this provision. And here are some key elements of what are the limitations or what are the conditions to get access to confidential information under such a confidentiality club. And the first condition here is that these confidential documents or this confidential information is kept in a sealed cover, is filed separately and kept by the court's register. So they don't, the other party does not have access to this information at all. It's kept in a different, let's say, in a different file, in a sealed file. If there is access, or access is granted only to the members of the confidentiality club, then there is an inspection possible, but it's limited only to these designated people, specifically designated people, and the inspection is done at the court's registry, and copies are not allowed in principle. So the parties that have been included, the persons that have been included in the confidentiality club, can look at the documents, but they cannot make copies of the documents. When they have gotten access to the documents, then another condition is that the members of the confidentiality club keep this information confidential. So they are under an obligation to keep this information confidential. When the information that's confidential or the documents are discussed in trial, in an oral hearing, then there is another limitation here. Only members of the confidentiality club can be present in court. So again, this safeguards this information by making it available even before court only to the members that have already are already allowed to have access to the information, not anyone else going beyond that. There are there is a condition that the court might allow exceptionally copies to be made, but then they would only be copies with reductions. And finally, the final condition here, which is also very interesting, is after the disposal of the matter, after the proceedings are done, there will not be any inspection anymore. So the inspection of the access to the documents only to the members of this confidentiality club ends also when the proceedings end. So here a relatively strict confidentiality regime limiting the access only to specific persons, and then also having significant safeguards here of how the persons, these designated persons, will get access to the information and are allowed to use this. So in general, this was the decision of the court here, and this is the status quo. This is how the court intends to move on with this in the proceedings going forward.